Good evening to all. Welcome to the second session of Contract Practice and Contract Administration Competency. If you have any questions, please post it in the Q&A chat room. We will run through it at the end of the session. I would like to remind you that today's discussion will be based on FIDIC 99 Red Book and Qatar context. You should be thorough with your standard form of contract or at least one standard form of contract. Let us start again with the interim valuation and payment provisions. Basically, we can say the following item must be considered when valuing the work executed. Preliminaries, measured work, value of variations, value of nominated subcontractors and suppliers, material on and off site where the contract permits, fluctuation in cost of labor, plant or material where the contract permits, loss or expenses, retention money, advance recovery, previous payment. You can see here the upper portion. As per subclause 14.3, contractor submit statement to the engineer. Within 28 days, engineer issue interim payment certificate to employer. So subclause 14.7, employer makes to the payment to the contractor. The total duration is 56 days. 56 days. You can see here within 28 days, engineer has to certify. After that, the employer will take another 28 days, total within 56 days. Let us see the next one. Here, the same thing it is mentioned. The payment process commences with the contractor submitting the statement to the engineer for processing. Because the payment commencement date will start from the submission of the contractor submission. Contractor submit statement to the engineer. So from here onwards, the time will start. So the contractor generally to submit 6 copies of the statement for processing. The default period is after the end of each month. The statement is to be an approved form and the contract requires that the first one show in detail the amounts to which the contractor considers himself to be entitled and accompanied by supporting documents. Whatever he is claiming, he should support all the documents. He should provide the evidence and supporting documents, including the relevant reports required under subclause 4.21. At the end of each month, submit monthly statement in respect of value of permanent work executed, any other items in the BOQ, material on or off site, any other sums, variation, claims, and etc. Upon receipt of the statement, deliver interim payment certificate to employer subject to retention, advance recovery, deduction other than LDs. Once the engineer receives, he will do the retention adjustment and also advance recovery if any, and deduction other than LDs. The LDs he can recommend, the employer will do that is up to him. That is the employer discretion to deduct or not. Okay. And in that payment schedule, whatever is there permits for the engineering overtimes, the rate of progress, the cost of insurance. If the contractor didn't take the insurance, the employer will take the insurance and he will deduct the premium in the payment application. These are the deductions I have mentioned. I have listed all these examples: payment to nominated subcontractor, any material supplied by the employer. schedule of payment. Subclause 14.4 provides the option of including in the contract a scheduled payment specifying the installment in which the contract price will be paid. The use of a schedule of payment allows an alternative to progress payment on the basis of value of work done for the milestone payments. FIDIC contemplates the possibility of two types of payment in FIDIC guide. The first one, schedule based on an amount or percentage of the contract price payable for each month and period of payment. A schedule based on actual progress achieved in executing the works. So these are the two types of payment. It is mentioned in the FIDIC guide. Now let us move to the plant and material. Subclause 14.5 set out an optional regime for payment of offside and unfixed plant and material intended for the works. The purpose of the subclause is to improve the contractor cash flow and minimize his financing cost. This is the main purpose of paying to the contractor for material offside in order to improve his contractor cash flow. So the next point, the default position is for the subclause not to apply where the contract contains no listing of plant and materials for payment when shipped or when delivered to the site. If it is not listed in the plant and material list, so the subclause not to apply. Payment for this material offside. If subclause 14.5 is to apply, the contract must contain a list in the relevant contract document of plant and material, a list in the relevant contract document of plant and material listed for payment when delivered to the site but not incorporated into the works. So you have to be very careful. The first one, when shipped. The next one, delivered to the site but not incorporated into the works. The engineer is to determine and certify amount only upon satisfaction of the series of express conditions in subparagraph A and B in the subclause 14.5, including keeping of satisfactory records available for inspection and submission of a statement of the cost of acquiring and delivering the plant and material to the site. We will look into that, how we have to certify the material offsite in the next chapter. These are the clauses mentioned in the FIDIC 99 Red Book. So I am just run through this one. Okay. Now, issue of interim payment certificate, subclause 14.6. The first one you can see, after the contractor has submitted his statement under subclause 14.3, and once the approved performance security has been submitted, you have to notice here, even if the contractor submits his interim payment certificate, he should submit his approved performance security as well. Otherwise, the engineer will not certify. Under subclause 4.2, the engineer is to review and process a statement under subclause 14.6. So he must submit the performance security as per clause 14, subclause 4.2. Subclause 14.6. The engineer is obliged to issue to the employer an interim payment certificate within 28 days after receiving the statement and supporting documents under subclause 16.1. We'll go back to that diagram. Actually, we are talking about, this is the timeline they have given, okay? The contractor submits statement to the engineer. From that, the time will start commence. Within 28 days, the engineer issue interim payment certificate. Then another 28 days, after 28 days, employer makes a payment to the contractors. So for this total duration, the timeline from contractor commencement till the employer payment, 56 days. This is for the interim payment. The final payment they have given in the down. So we will look into that after that while we are reviewing that clause. So simply illustrated in that diagram, these points, you can read, which is self-explanatory actually. The third point, if an interim payment certificate is an amount which would, after retention and other deduction, be less than an agreed minimum amount stated in the relevant contract document, the engineer is not bound to issue an interim payment certificate. Which means some of the contract, in the appendix to tender, they will mention this is the minimum amount the contractor has to submit. For example, 1 million, 2 million, like that. Let's say if it is mentioned in 1 million, while the engineer is reviewing, if it comes 800,000, the engineer is not bound to issue an interim payment certificate, but must give the contractor notice accordingly. He can notify to the contractor, this is the minimum amount specified in the contract, in the appendix to tender 1 million, but now the current year payment application is coming around 800,000, like that. He has to notify. He has to give the notice to the contractor. The fourth point, certification may be withheld under subclause 4.6a and b as well as subclause 14.3c. So you have to refer these clauses, but it is mentioned in that subclauses. The final paragraph of subclause 14.6 gives the engineer right to correct or modify previous payment certificate. The engineer has a right to correct or modify previous payment certificate. For example, if we made any mistakes or careless mistakes or some wrong information, so he can correct it or modify it in the next payment application, because this is all interim payment. The next one, payment subclause 14.7. The employer shall pay to the contractor the first installment of the advance payment within 42 days after issuing the letter of acceptance, or within 21 days after receiving the documents in accordance with the subclause 4.2 performance security and subclause 14.2 advance payment, whichever is later. B, the amount certified in each interim payment certificate within 56 days after the engineer received the statement and supporting documents. C, the amount certified in the final payment certificate within 56 days after the employer received this payment certificate. So we have seen in that diagram, it is simply illustrated. So engineer will take 28 days, the employer will take another 28 days. So total 56 days from the contractor submission to the payment. This is for the interim payment application. Delayed payments. If the contractor does not receive the payment in accordance with subclause 14.7, he is entitled to receive financing charges, that is interest on the unpaid amount. This is what mentioned in the FIDIC 99 Red Book. So contractor is entitled to receive the interest on delayed payment, unpaid amount. Let us move to the payment of retention money, subclause 14.9. When the TOC has been issued for the works, works means whole works, the first half of the retention money shall be certified by the engineer for payment to the contractor. The second one, if a TOC issued, taking over certificate issued for the section or part of the work, 40%, they will calculate that, they will estimate that portion of that amount, and 40% calculate by dividing the estimated contract value of the section or part by the estimated final contract price. If the TOC issued for a section or part of the work, a proportion of the retention money shall be certified and paid. This proportion shall be 40% of the proportion calculated by dividing the estimated contract value of the section or part by the estimated final contract price. The next point, if any works remain to be executed under clause 11, defects liability, the engineer shall be entitled to withhold certification of the estimated cost of this work until it has been executed. The fourth one, when calculating these proportions, no account shall be taken of any adjustment under subclause 13.7. So while we are calculating this 40%, we will not do any adjustment for the changes in legislation as well as adjustment for changes in the cost. Because these things, they have given the formula in the FIDE, you can look into that. Okay, statement at completion. This is a final statement. The subclause set out procedure by which the contractor submit the statement at completion. Within 84 days after receiving the TOC for the works, the contractor shall submit to the engineer 6 copies of the statement at completion with supporting documents in accordance with subclause 14.3, application for interim payment certificate, showing that A, the value of all work done in accordance with the contract up to the date stated in the TOC for the works. B, any further sums which the contractor considers to be due. And C, an estimate of any other amounts which the contractor considers will become due to him under the contract. Estimated amounts shall be shown separately in this statement at the completion. Because they have given the, they have set out the procedure in the subclause 14.10, how you have to submit the statement at the completion. The engineer shall then certify in accordance with subclause 14.6, issue an interim payment certificate. Application for final payment certificate. The contractor is to make his payment application for the final payment by way of final statement. The contractor's right to make an application is subject to the condition that the performance certificate has been received. Thereafter, he must, within 56 days of receiving the performance certificate, submit 6 copies of a draft final statement to the engineer with supporting document showing in detail. The second paragraph set out the regime for processing and agreeing the draft final statement and entitle the employer to require the contractor to submit such further information as the engineer may reasonably require and to make such changes as they may agree. We'll go back to the second slide. You can see here the bottom diagram, the final payment. Subclause 14.11, contractor submit draft final statement to the engineer. So he will take 28 days. Engineer verifies statement, contractor submit information. After 28 days, Once the engineer reviews, verifies, again, contractor submit final statement and the discharge certificate. Then engineer will take another 28 days. Then engineer issue the final payment certificate to employer. So employer will have another 56 days. Total duration is 112 days. From submission to employer makes payment, total is 112 days. 56 here, 28 plus another 28. The interim payment is total 28 plus 28, total 56. So everything is commencing from the contractor submission date. This is the most important. Generally, they are asking this question in the APC panel, how the time will commence, when the time will commence for the interim payment certificate as per the FIDIC 99. So you have to say from the contractor submit statement to the engineer. So from that, the clock will start. This is what simply illustrated in this diagram. So here is the narrative actually. I have just highlighted it, this red and also green as well, the draft final statement to the engineer. This is for that diagram's narrative. And the fifth point, the final paragraph of subclause 14.5 provides that if following discussion on any changes to the draft final statement, it becomes evident that a dispute exists. Because if the contractor and the engineer did not agree or is there any dispute, then engineer is to deliver an interim payment certificate to the employer with the agreed parts of the draft final statement. If the dispute is resolved by the Dispute Adjudication Board, DAB, under subclause 20.4 or by amicable settlement under subclause 20.5, the final sentence of subclause 14.11 provides that the contractor is to prepare a final statement. So is there any dispute? Everything is perfect and the engineer also satisfied as per his contractor submitted. So the contractor will submit the final statement. If it is any dispute only, if both parties cannot agree, they have to follow the DAB as per clause 20, and the engineer will issue the interim payment because there is a dispute, so he cannot issue the final, so he will issue the interim payment. Discharge. While we are submitting the final payment certificate as per the FIDIC 99, subclause 14.12, the contractor has to submit the written discharge certificate with the final statement. Let's see. When submitting the final statement, the contractor is to submit a written discharge confirming that the total of the final settlement represent full and final settlements of all monies due to the contractor under or in connection with the contract, along with the final statement. While giving this discharge certificate, they will put two conditions. You can see here, subclause 14.12 provides that the discharge may be conditional and state that it becomes effective only after the contractor has received the performance security and the outstanding balance of the agreed final statement. So while giving the discharge certificate, the contractor will mention these two conditions. So he will state the employer has to return the performance security performance bond, and also he has to pay whatever it is mentioned in the final and full and final. That's the outstanding amount he has to pay to that specified account. Otherwise, this discharge certificate will not be effective. Issue of final payment certificate, subclause 14.13. Subclause 14.13 obliges the engineer to issue the final payment certificate within 28 days after receipt of the final statement and contractor discharge. Okay, the contractor has to submit the final statement, as well as with that he has to submit the contractor discharge. The final payment certificate is to state the amount which is finally due and the balance, if any, due from the employer to the contractor or vice versa. Maybe the employer, contractor has to pay something to the employer, the advance recovery, let's say some material supplied by the employer, vice versa. In any case, after giving credit to the employer for all amount previously paid and all sums to which the employer is entitled. If the contractor does not apply for final payment certificate under subclause 14.11, the engineer is first to request the contractor do so. And if the contractor does not do so within 28 days, issue it in amount he fairly determines to be due. In some cases, contractor will not apply for any final payment certificate. For example, this is not ethical. If the contractor let's say if a contractor, suppose if he realize he has to pay back to the employer, then he will not submit. That is not ethical. So in that case, the engineer, he has to request to the contractor to submit the final statement. Otherwise, he has to issue the amount he fairly determines to be due. Okay, let us move to the next chapter, material on and offsite. Generally, they used to ask this question, how to pay material on site, how to pay material off site, like that. So the first one, how to pay material on site. First of all, we have to make sure there is a provision in the contract. Then we must check that material is listed in the contract to pay as material at site required for the permanent future works. First, we have to make sure there is a provision in the contract. Second one, we must check that material is listed in the contract and also the material at site required for the permanent future works. And check whether the materials are delivered to the site, properly stored and protected and approved by the engineer. Then we can certify the approved material quantity as per the percentage value of invoice value mentioned in the appendix to the tender. In the appendix to the tender, generally they mention 70% of the invoice value, otherwise BOQ. Sorry. Otherwise, the BOQ quantity like that, they will mention in the percentage in the appendix to the tender. Based on that, he has to certify. Okay, sorry. Next one, how to pay material offsite. This is most popular question in the APC panel. First of all, we have to make sure there is a contractual provision. If there is no provision, party has to agree by a supplementary agreement. That material shall be listed in the contract. Material shall be stored properly and shall be approved by the engineer. Contractor must provide the vesting certificate to transfer the ownership of the material to the employer. The purpose of vesting certificate is to transfer the ownership of the material to the employer in the event of the supplier or subcontractor bankrupt. Those materials shall be insured properly because the contract insurance policy do not cover off-site material because he is storing in the off-site, outside of the work site. So he has to provide, he should provide the insurance for that work. And clearly marked and separated from other materials. And also factory inspection certificate should be submitted with that invoice. This is the how to pay material offsite. This is most popular questions in the APC panel. So you have to make sure, you have to give the answer like this. These are the steps actually. Okay. Fluctuation. The increase, so this is the next chapter in the study checklist, which we discussed in the session 1. The increase or decrease in cost of labor, plant material that may occur during a contract. There are two methods. One is formula method, other one is conventional method. So I have given what is that formula method. Many standard firms provide for the use of formula to calculate fluctuation in cost on fluctuating price contracts. The conventional method, an alternative approach, is what has become known as a conventional method. Suppose 13.8, adjustment of changes in the cost. They have given the formula in the FIDIC 99 red book. So based on that, we have to calculate the fluctuations. Some standard contracts, they have given the norms, how to calculate the fluctuation and all. So based on that formula or norms, so you have to do. Now let us move to the next chapter, change management procedure. Be familiar with the procedure as per your contract. This is also one of the most popular questions in the APC panel. Generally, in the APC panel, from this contract practice and contract administration, they used to ask around 6 to 7 questions for these both competencies. 6 to 7. Most of the questions will come from these two competencies only. With other competencies, they might ask 1 or 2. Okay, maximum 3, but these two competencies, they will ask more questions. So you have to be familiar for these things. And this is a change management procedure also. Be familiar with the procedure as per your contract. Contract shall only do instructed changes except suspension of part of the work can be considered omitted. Let us see the next page because I have attached here, I have given one change management procedure. Let's see the next slide. I have put it a little bit big. I'll just explain you the simple way. Here, generally, the change request for change can be initiated by either party, either contractor or employer. Once a contractor initiated, then he will submit to the engineer. What engineer will do, he will review first. Okay. In that request for change, the contractor will put the estimated amount and he will give time and cost, both. Okay. Once the engineer received, he will review. If he wants further information, he will discuss with the contractor, he will request the contractor. Otherwise, based on that available information, he will evaluate, okay, he will verify that changes. Then if it is a valid change, then he will advise to the employer. Once the employer received and he will review, then if it is approved, because the employer will send it to budget control department. You can see in the top, the budget control, okay. Once the budget control approved that one, then only the employer will instruct engineer to issue the engineering instruction. After that, it will be formalized. Okay, based on once he received the engineering instruction, as per the contract, he has to submit his notice and all the supporting documents. This is a general summary. Okay, otherwise, if the engineer wants to give any variation, so straight away, internally they will discuss, engineer and employer, and they will get the budget control, the approval and all. Immediately they will issue the engineering instruction based on once the contractor received, he will give the notice as per the contract, and he will submit his all the evidence, supporting documents and everything. Okay, this is the general change management procedure, but you have to be familiar with your change management as per your contract. Here I have given the change may arise from the request for information. He will ask some information, the contractor will comment. So the contractor will say, no, the engineer will comment, the contractor will say, this is not in my contract. So then he will issue the request for change. This is another change. Like the site instruction and the drawing issues and employee changes. These are the 4 pro forma documents. This is what I mentioned in the doubt. So this is the general change management procedure. So you should be thorough with your change management process as per your contract. Generally, they are asking these questions in the, they will ask, could you explain the change management procedure as per your contract? Okay, now let us look what FIDIC 99 says. Variation procedure, subclause 13.3. The variation provision in subclause 13.1 and 13.3 investigate that the variation may be initiated either by a request to the contractor to submit a proposal or by an instruction. Okay, this is a way of requesting the variation. Either engineer can ask contractor to submit the proposal, or otherwise he can give the instructed instruction. The second point, subclause 13.3 in particular set out the procedure and related requirement that are to apply to variations. The first 2 paragraphs of this subclause relate only to proposals submitted in response to the request. The third paragraph related to instruction, and then final paragraph set out the basis for valuing the variations. So the first 2 paragraphs, it is response to the request for the proposal. The third paragraph related to the instruction. The fourth paragraph, how the basis of the valuing the variations. Now here, if the engineer requests for a proposal prior to instructing the variation, the contractor shall respond in writing as soon as practicable, either by giving reason why he cannot comply or by submitting. If you want to reject, he has to give in writing what is the reason. If you want to proceed, if you want to submit the proposal, so he has to include this ABC. A description of the proposed work to be performed and the program for its execution. B, the contractor proposal for any necessary modifications to the program according to subclause 8.3 and to the time for completion. C, the contractor proposal for evaluation of the variation. So these 3 he will include by in his response in writing. The second point, the engineer shall, as soon as practicable, after receiving such proposal under subclause 13.2, value engineering or otherwise, respond with approval or disapproval or comments. He has to make full comments, the detailed comments. The contractor shall not delay any work whilst awaiting a response. The contractor cannot say, once I receive the approval only, I will execute this work. He cannot say like that. Contractor shall not delay any work whilst awaiting a response. Each instruction to execute a variation with any requirements for the recordings of costs shall be issued by the engineer to the contractor, who shall acknowledge receipt. Each variation shall be evaluated in accordance with the subclause clause 12. Measurement and evaluation unless the engineer instruct or approve otherwise in accordance with this clause. So the evaluation as per the clause 12. Now let us move to the next chapter, valuing change, variation and compensation events. Be familiar with the procedure as per your contract. Okay. Let us look what FIDIC 99 says. Work to be measured, subclause 12.1. Method of measurement, subclause 12.2. Evaluation, subclause 12.3. This FIDIC 99 evaluation little bit different, okay, little bit different, a little bit complicated. The engineer is required to agree or determine the value of each item of work, applying measured quantities to rates and prices in accordance with this subclause. The second paragraph confirms that for each item, the appropriate rate or price shall be A, the rate or price specified for such item in the contract, or if there is no such item, the rate or price specified for similar work, in certain defined circumstance, a new rate or price shall be specified. So each of the grounds as set out above is looked at individually. So you have to familiar with that as per your contract for this evaluation of the variation. FIDIC, if it is a FIDIC 99, you have to read and understand how we have to do the evaluation. Now let us move to the next chapter, extension of time. Here I have given the history of extension of time. The introduction of extension of time clauses in construction contract arise from a decision in Allman Puppy in 1838. So this is the history you can read. Okay. Now let us look at what FIDIC 99 says. Extension of time for completion refers subclause 8.4, extension of time. The entitlement to an extension of time under the contract is one of the most important of the contractor's remedies. Once a project is prolonged, so the contractor will have the remedies. Remedy means he will have an extension of time. That is dependent on the scenario, the grounds. This entitlement is principally governed by subclause 8.4. Let us look at. Okay. Grounds for entitlement to the extension of time. There are 5 grounds in the FIDIC 99 Red Book, as well as FIDIC 87 also there are 5 grounds. The first one, variation. Second one, a cause of delay giving an entitlement to the extension of time under the subclause in the conditions. Third one, exceptionally adverse climatic condition. Fourth one, unforeseeable shortage in the availability of personnel or goods caused by epidemic or governmental actions. The last one, any delay, impediment or prevention caused by or attributable to the employer, the employer's personnel or the employer, other contractors on the site. So these are the 5 grounds will give the entitlement to the extension of time. Now look at the question. This is also one of the most popular questions in the RICS. This is possible questions. How do you evaluate extension of time claim? So these are the steps. you have to give step by step to the panel. You have to give the answer like this. According to the, as per my contract, you can say, subclause 8.4 of FIDIC 99 Red Book, contractors entitled for extension of time under 5 events, 5 grounds. First of all, check the EOT claim is submitted under which event of subclause 8.4. Check the event is valid and who is liable in accordance with the contract. Check whether the contractor has taken any mitigation actions. Check whether the contractor has complied with the notice requirement. These are the steps you have to explain to the panel. Check whether the notice provision is condition precedent for granting extension of time. If all satisfied, check whether detailed particulars are submitted within the time stipulated in the contract. If the event is continuing effect, check whether the interim particulars are submitted. When the event is over, check whether the final particulars are submitted within the time stipulated in the contract for the end of the event. If all satisfied, I will advise the planning department to determine the extension of time. We will request to the planning engineer to determine the extension time. Then if the contractor is claiming any cost, then check whether the contractor is complied with the notice requirement as per the contract. So the previous one we have given for the time notice. Now we are moving to the cost. If the contractor is claiming for the cost, so he should follow. Okay, he has to give the notice. Check whether he has maintained contemporary records and submitted the detailed particulars within the time stipulated as per the contract. If it is a continuing effect, check whether interim particulars have been submitted as agreed by the engineer. Check whether the final particulars have been submitted with the time stipulated in the contract for ending that event. If the submitted details are not sufficient, evaluate according to the available details. Whatever you have, whatever you received from the contractor, based on that you have to evaluate. So this is one of the most popular questions, not only in the RICS as well as the job interview as well. If you are going for the contract administrator or the contract manager or contract especially, they used to ask these kind of questions. So you have to be familiar with this one. Step by step you have to provide the answer. Liquidated damages, the FIDIC, this is called delay damages. If a contractor does not complete the work on time, then in the absence of any other provision, he is in breach of contract and liable to pay damages to the employer. This type of damage is referred to as the liquidated damages. Liquidated damages, also referred to as liquidated ascertained damages, are damages whose amount the parties designate during the formation of the contract for the injured party to collect as a compensation upon specific breach. These are a genuine pre-estimate of the damage that the employer might sustain in the event of late completion. Sometimes they might ask, what is your understanding of liquidated damages or delay damages? So you have to say these are a genuine pre-estimate of the damage. As per Qatar context, this can be challenged. Employer has to prove he has suffered that much of amount of money. So as per Qatar Civil Code, this can be challenged. Now let us look at what FIDIC 99 says. If contractor fails to comply with subclause 8.2 time for completion, the contractor shall subject to subclause 2.5 employer's claim, pay delay damages to the employer for this default. These delay damages shall be in the sum stated in the appendix to the tender. Generally, they mention in the appendix to the tender, for example, 200,000 real per day, 500,000 real per day, like that they will mention. The total amount due under this subclause shall not exceed the maximum amount of delay damages stated in the appendix to the tender. In the appendix to the tender also, they will mention the maximum ceiling of the LD. They will mention 10% of the contract sum. Sometimes they might say 10% of the revised contract sum. Once there is, in some contract I have seen, they mention 10% accepted contract price. For example, if it is 100 million is accepted contract price, maximum 10 million the employer can claim LD. In some contractors I have noticed, they mention 10% of the revised contract sum or latest contract sum. Delay damages, liquidated damages for delay are probably the best known of the remedies available to an employer under an engineering or construction contract. This remedy is called delay damages in the FIDIC forms. The contractor's liability for delay damages is governed by subclause 8.7. Liquidated damages subclauses are valuable to an employer because generally they remove the burden of having to prove the requirement of an actual loss. This is most important. The legal effect and enforceability of the liquidated damages provisions are complicated and very dependent on the governing law of the contract. Damage could include loss of return on capital, professional cost, loss of income, extra cost of fluctuations, extra cost of other works, commissioning, cost of hiring alternative accommodations. These are the delay damage could include. Cost headings. Three classes of delay can be identified in the contract. The first one, excusable, compensable, which means delay for which the employer is responsible. These delays entitle the contractor to an extension of time and recovery of any loss and expense caused by the delay. The second one, excusable, non-compensable. That is, delay caused by events for which neither party is responsible, also known as neutral delay or neutral events. These entitle the contractor to an extension of time, but he cannot recover from the employer any loss and expenses he incurred as a result of the delay. Equally, the contractor is not liable to pay damages for the delay to the employer. All losses lie where they fall. The third one, non-excusable, non-compensable. That is, delay for which the contractor is responsible, also known as culpable delay. These do not entitle the contractor to an extension of time. He is liable to the employer to pay delay damages. And any loss or expense he incurs are irrecoverable. Let us see concurrent delay. It very often happens that there is more than one cause of delay in a construction contract operating at any one time. At any one time. For example, a situation where the employer has failed to deliver necessary materials, but the contractor does not have the necessary men on site to use them, and at the same time the weather is exceptionally adverse to that the work could not be carried out in any event. So here they have given three scenarios. The first one is the situation where the employer has failed to deliver the necessary material. The contract agreed the employer will deliver some materials. For example, these are tiles and all. So the first scenario, the situation where the employer has failed to deliver the necessary materials. The second scenario, but the contractor does not have the necessary men on site to use them. Employer didn't deliver that material. At the same time, contractor also does not have the men to use them. The third scenario, at the same time, the weather is exceptionally adverse so that the work could not be carried out in any event. So these three scenarios, so this is called the concurrent delay. Okay. So the definition is very often happens that there is more than one cause of delay in a construction contract operating at any one time. Critical activities. Critical activities are those that directly influence the earliest time that a project can be completed. The main characteristic of critical activity is that it has no spare time attached to it. It must be completed at the time required and within the duration fixed for it. Otherwise, the project completion date will not be achieved. In contrast, non-critical activities do have spare time, referred to as float. We call it as a float. And the pressure to complete these is less intense, giving project managers some flexibility in their start and finish. So you have to look into that. What is critical activity, critical path, and float? I have given the definition, next slide, for the critical path. Critical path, the sequence of critical activities running through the project from start to finish is termed the critical path. That is longest path in the program. Simply we can say critical path means longest path in the program. Free float, difference between early start and late start of an activity. Milestone, a section in a project that must be completed on a particular date. It should be specified in the contract. Mitigation versus acceleration. Mitigation means contractual obligation, contractor obligation to mitigate any delay event. Whereas acceleration is done upon instruction from the employer or engineer, except in the case of constructive acceleration. For example, if it is a delay progress, rate of progress is slow progress, then engineer will say submit the revised program as well as do the constructive acceleration. He has to catch up that date, whatever he has mentioned in his program. Now let us move to the next chapter, programs. The contract requires the contractor produce program to show how the works are to be executed in order to meet the contractual completion date. Generally, contractors are required to warrant that the program shows the sequence in which he proposes to execute the works. So Detail of any temporary works, method of working and labor and plant he proposes to employ is achievable, conforms with the requirement of the contract, permits effective monitoring of the work, allows reasonable time for the employer to provide any additional information required. These are generally contractors required to run that program. Now, let us look what FIDIC 99 says. As per subclause 8.3, the program will set out the anticipated order, timing, and duration of the different task or activities, works or sections being completed within the time for completion. Contractor is required to submit the program within 28 days of receiving the notice of the commencement date under subclause 8.1. Subclause 8.3 requires the contractor to submit revised programs when the current program does not reflect any of these matters. Content of the program. The key information that must be included in the program in accordance with subclause 8.3, the order in which the contractor intends to carry out the work. They might ask what is the purpose of submitting the program. The APC panel, they might ask this question. So the contractor intend to, the method the contractor intend to carry out the work. The anticipated sequence and timing of the various stages involved, including procurement, manufacture of plant, delivery to site, construction, erection, testing, commissioning. Each of the stages for work by each nominated subcontractor. The sequence and timing of inspection and test is specified in the contract. So these are the content of the program. You should know the delay analysis methodologies. They might ask these questions, but actually this is the competence of planning engineer, but you should be aware, you should know the names of these methodologies. Impacted as planned, collapse as built, time impact analysis, as planned versus as built, time slice window analysis. Now let us move to the next chapter, loss and expense claims. Claim is defined as a legitimate request for additional compensation of time and or cost on account of change or breach of the terms of contract. Claim is defined as a legitimate request for additional compensation of time and or cost on account of a change or breach of the terms of contract. Expense means additional cost to maintain the site facilities. Loss means loss of opportunity to make profit elsewhere due to employees' delay. Claims can be grouped under the following headings. The first one, contractual claims, where the matter is covered within the terms of the contract, but the contractor and client representative cannot reach an agreement. The next one, extra contractual, means legal. A claim of right which would be enforceable at law, but it is not covered within the contract. The third one, ex gratia claim, out of kindness. The claim having no legal foundation, but which warrants consideration on grounds of hardship or perhaps on moral grounds. This is out of kindness, the employer might give this ex gratia claims. We have received one claim in UAE, ex gratia claim, while I was in UAE. Okay. Structure of a claim. So there are four structures: defect, legal basis, liability, quantum. Effects means the contemporary record, witness statement, minutes of meeting, news, site diary, like that. Legal basis, contractual and legal provisions. So we have to mention liability, employer liable to provide relief, quantum, amount of EOT and no additional payment. The next one is heads of claims. Generally, these are the items which will be considered for payment. The first one, cost of running the site during an extension period, the prolonged period. Disruption where there is no delay to the work but additional cost, loss of productivity, hindrance, head office overhead. There are few formulas to calculate this head office overhead, Emden formula, like that. Loss of profit, very difficult to prove this one. This is very complicated one. Fluctuations, finance charges. These are the heads of claims. You should be know. Now let us see this, look at what FIDIC 99 says, the clause 20, claims, disputes and arbitration. You can see here, once we receive the commencement date as per subclause 8.1, as per 20.2, parties appoint the DAB within 28 days. Okay. As per subclause 20.4, a party refers to a dispute to the DAB. Parties present submission to the DAB 84 days. And DAB gives its decision another 28 days. A party may issue a notice of dissatisfaction. Then again, the amicable settlement, 56 days. So these are the timeline mentioned in the FIDIC 99 for these claims, disputes and arbitration. So you should read and understand and familiar with your contract, what it says. So this timeline, some of the contracts may be varied. Okay, so this is the FIDIC 99 Red Book. They have given the typical sequence of dispute events envisaged in the clause 20. Okay, now let us move to the outline of procedure for claims under subclause 21. Here you can see the contractor must notify, submit and keep contemporary records. So I have given small narratives for each and every activity because there are 3 activities here: notify, submit and keep contemporary records. And I have given the example for this contemporary record as well. The first one, the contractor is required to give notice to the engineer describing the event or circumstance giving rise to the claims as soon as practicable and in any event not later than 28 days after the contractor became aware or should have become aware of the event or circumstance. Then submit within 42 days of when the contractor either became aware of or should have become aware of any event or circumstance, a fully detailed claim and full supporting particulars. So within 28 days, so he has to submit fully detailed claim and full supporting particulars. Whatever you are claiming, you should provide the supporting documents, means evidence, quotation like that you have to give. Keep contemporary records. Example, idle time of resources, abortive works, protective measures, demobilization and remobilization records, photos, minutes of meeting, site diaries, resource utilization patterns, correspondence, news and articles to support his claim and permit the engineer to inspect these records. Whenever the engineer wants to inspect these records, you have to give the permission. Permit the engineer to inspect these records, obtain copies or instruct for additional record. Even if the engineer wants more details, more information, he can instruct to the contractor. We need this kind of information, this kind of evidence, this kind of quotation like that. He can instruct to the contractor. On the other hand, the engineer must respond within 42 days of receipt of a claim, either approving, disapproving, or requesting further particulars, all with detailed comments. So, the engineer must respond within 42 days of receipt of the claim, either approving, disapproving, or requesting further particulars, further information. Or he has to give detailed comments. He cannot just reject or he cannot just approve. If it is approved, means he will put the reference number on all the basis. If he wants more further details, he has to give each and every item, he has to comment it. In any determination pursuant to subclause 3.5, consult with all parties to attempt to reach an agreement and make a determination. If agreement cannot be reached in accordance with the terms of the contract, taking due regard to all relevant circumstances. Determination, subclause 3.5. The engineer is required to proceed in accordance with subclause 3.5 to agree or determine. Either agree or determine extension of time, EOT, of the time for completion in accordance with subclause 8.4, and the cost, the additional payment to which the contractor is entitled under the contract, if any. So these are the determination. The engineer has to give the determination. If there is an extension of time, he has to give. Otherwise, if there is a cost, he has to give, or both. The next one, dispute adjudication board. Most FIDIC forms provide for a multi-tier dispute resolution mechanism, and commonly used method for resolution of dispute is 4 steps. The first one, the decision of the engineer who is employer agent managing the construction project. Second, the decision of the engineer can be revised by a dispute adjudication board, which is an independent panel of 1 or 3 construction experts who issue their decision. See here, once the commencement date issued as per subclause, within 28 days, the party has to appoint the dispute adjudication board within 28 days as per subclause 20.2. This is what they are telling here. This is what they say. Okay, the decision of the engineer can be revised by a dispute adjudication board, DAB, which is an independent panel of 1 or 3 construction expert who issue their decision. Third, the parties should attempt an amicable settlement of their dispute. And finally, the last remedy is for dispute to be solved by binding arbitration or litigation, depending on the agreement of the parties in the particular condition of the contract. Either they can go to the arbitration or litigation. So these are the 4 steps. Let us move to the next chapter, dispute avoidance and resolution. Dispute avoidance, choose the correct procurement path, ensure proper coordination between the parties, provide timely response to all the tender queries and circulate to all the tenderers. Use standard forms as much as possible because that is risk tested document, risk balance. all the parties know the familiar with that document. Allow sufficient time to finalize contracts. Appoint qualified professional to prepare and administrate the contracts. Now let us move to the next one, arbitration. Arbitration is a process of settlement of any dispute by an independent third party known as an arbitrator. A key factor being that judgment will be made by opinion based on the evidence presented. So arbitration is the process of settlement of any dispute by an independent third party known as an arbitrator. Characteristic of arbitration. There are a number of characteristics which make arbitration favored process: speed, to cost, thoroughness, finality, reasons, privacy, evidence. You can read, these are the, sometimes they might ask these questions. What is the advantage of going for the arbitration? What are the disadvantages of litigation? Sometimes you might compare and contrast arbitration and litigation as well. So you should know these are the characteristics of arbitration. Then you have to compare and contrast with the litigation. Challenging an award, arbitration award. A party may challenge an award due to lack of substantive jurisdictions, due to a serious irregularity. So these are the two grounds to challenge an arbitration award. The next one, litigation. The courts are available to anyone who has a legitimate claim recognized in law. If it is mentioned in the particular conditions, litigation, so you cannot go to the arbitration, you have to go to the litigation. But before going to the litigation, they will ask, are you try to settle amicably or not? Like that, they might, the judge or courts, they will question. You can see here alternative dispute resolutions, ADR, negotiation. The most common dispute resolution form used in the construction industry. Parties can settle their dispute at any time, willingness to compromise. The next one is a mediation. They used to ask this question as well. So you have to familiar for this one. You should read and understand, and you have to explain. Mediation means that both parties appoint an independent third party as a mediator. The mediator then discuss individually with the parties and try to narrow down the gap of the dispute in order to bring a conclusion. This is called mediation. Conciliation, same as mediation, but the independent third party conciliator gives his opinion of the dispute. Mid-up. This is a combination of mediation and arbitration where the parties agree to mediate, but if that fails to achieve a settlement, the dispute is then referred to an arbitrator. The same person may act as a mediator or arbitrator. Expert determination. Both parties appoint an expert third party for a particular dispute and obtain his determination of the dispute. This can subsequently be considered by the court as well. Neutral evaluation. Neutral person give an opinion after hearing each part case which can be used as a basis for settlement. Dispute review board. An independent board evaluates dispute as similar to the DAB in FIDIC 99 Red Book. Mini trial, it involves a representative from each company presenting the evidence in their case to a neutral panel and senior executives from each of the companies in the dispute. Now let us move to the next chapter, name and nominated subcontractor. There are three types of contractors. The one is domestic contractor or in-house contractor, appointed by the main contractor as per his own requirement, subject to the approval of the engineer. For example, labor supplier, false ceiling works, waterproofing works, and so on. The next one, named contractor, appointed by the main contractor from the list provided, included in the documents by the employer. During the tender, the employer will issue the preferred vendor list in the tender document. We have seen some, we mentioned in the session 1. So if it is, if for example, if the tile supplier is there, then no need to get the approval. You just notify to the engineer. This supplier, it is already named in the contract document. So we are moving with this guy, like that you can notify. The other one is nominated subcontractor. This is appointed by the employer but contract with the main contractor for specialty works. Example, MEP works, lift works, ID works, aluminum and glazing, landscaping, swimming pool works. These are the specialty and specialized work. So employer will appoint the nominated contractor and the main contractor will have the contract with that nominated contractor. Once he contract with that contractor, automatically he will become a nominated contractor. So employer obligation towards nominated subcontractor. Selection and appointment of the suitable subcontractor on time. Nominate another subcontractor if the main contractor raises reasonable objection. The FIDIC 87, okay, I think close 56 or something, I can't remember. You can give a reasonable objection. And the third one, making direct payment to nominated subcontractor in case of main contractor's failure. Appoint another subcontractor if the nominated subcontractor fails to perform. So these are the obligations from the employer towards nominated subcontractor. Let us move to the next chapter, employers taking over, sectional completion, partial possession. Let us look what FIDIC 99 says. Actually, in the FIDIC 99, subclause 10.1 set out the standard procedure and condition for the issue of taking over certificate in respect of the works or section. Although they are principally drafted in relation to the works, the second paragraph makes it clear that the same provision apply to sections if appropriate. So I have summarized all the consequences, okay, summary of consequences that follow the issue of taking over certificate, depending on the aspect of the works in respect which the certificate is issued. Works all on issue of TOC for the works, whole works. The contractor is required to submit the statement at completion within 84 days after receiving the TOC. So these are the consequences after issuing the TOC. The insurance cover required for the works and contractor requires is reduced. Engineer power to initiate variation cease. Any outstanding repayment due in respect of the advance payment becomes immediately due and payable by the contractor. Contractor is no longer required to submit revised cash flow estimates if applicable, and restriction lifted on minimum amount that may be certified in an interim payment certificate. So you should be thorough, you should be familiar as per your contract. What are the consequences after issuing the taking over certificate? Okay, you should be thorough and you should be familiar with your, as per your contract, what are the consequences after issuing the TOC. So works and sections. Responsibility for care of the whole of the works and section passes back to the employer on issue of the TOC. Liability for delay damages is on that day stated in the TOC for the section or the works or in case of part of the works. Defect notification period commences on the date on which the works or section is completed as stated in the TOC. The first half of the returns of money held in respect of the works or section is to be certified and paid to the contractor when the TOC has been issued. Have passed all specified tests. So these are a few definitions and you should know it. Defect notification period means the period for notifying defects in the works or section. Sectional completion, completion of any section for which separate time for completion provided in the contract. It should be specified in the contract. For example, if it is a mixed-use development, let's say 5 basements and hotel floors, let's say another 10 hotel floors and another 20 apartment floors. So they will divide into 3. These 5 basement, one date, they will give one date. And for the hotel floors, they will give another date. And the apartments, they give another date. So these are the section completion and they will specify it in the contract. So once you finish the 5 basement, you have to hand over this date. Like that they will mention. So completion of any section for which separate time for completion is provided in the contract. Partial possession. Occupation or use of any substantial part of the permanent works by the employer, either before or after completion to the satisfaction of the engineer. In both cases, the contractor may request and the engineer shall issue the TOC. Requirements for issuing the TOC. The permanent work should be substantially completed, satisfactorily pass all tests on completion, and written undertaking from the contractor finish any outstanding work during the defect notification period. For this, a snagging list, punch list. So here the contractor has to give written undertaking from the contractor finish any outstanding during the defect notification period. Substantially completion means the employer can take beneficial use of the project for its intended purpose. Contractor is still liable to complete the project in its entirety but entitled to receive TOC. So this is the meaning of substantial completion. Now this is the last chapter of this contract practice and contract administration competency. Termination. It is common for most commercial contract to grant one or both parties certain rights to terminate the contract in certain circumstances. The general remedy that is available to one party where the other party is in breach of contract is a right to recover damages from that other party to compensate the first party for the losses suffered as a result of the breaches. You can see here termination by the employer means default of contractor. There are few grounds. The employer shall be entitled to terminate the contract if the contractor fails to comply with the subclause 4.2 performance equity with the notice under subclause 15.1 notice to correct. Abandon the work or otherwise plainly demonstrate the intention not to continue performance of his obligation under the contract. This is second ground. Third, without reasonable excuse fails to proceed with the works in accordance with subclause 8, commencement, delays and suspension, or to comply with the notice issued under subclause 7.5, rejection, or subclause 7.6, remedial work, with 28 days after the receiving it. The third one. D. Subcontract the whole of the works or assign the contract without the required agreement. He can subcontract some part of the works with the approval of the engineer. If he subcontract the whole of the works or assign the contract without regard, so employer has an entitlement to terminate the contract, employment of the contract. He become bankrupt or insolvent, goes into liquidation as a receiving or administration order made against him, compounds with his creditors or carries on business under the receiver, trustee or manager for the benefit of his creditors. F. Gives or offers to give directly or indirectly to any person any bribe, gift, gratuity, commission or other thing value as an inducement or reward. So this is also one of the ground the employer has an entitlement to terminate the contract. So these are the grounds which we discuss here. So this is valuation at date of termination, because this is default of contractor. The financial consequences following termination by the employer under subclause 15.2 are principally set out in subclause 15.3, valuation at date of termination, and 15.4, payment after termination. In summary, I have summarized this one. As soon as practicable after the notice of termination has taken effect under subclause 15.2, the engineer is required to proceed in accordance with the subclause 3.5 to agree or determine the value of works, goods and contracted documents and any other sums due to the contractor for the work executed in accordance with the contract. The employer is not obliged to pay any further amounts to the contractor until the cost of completing the execution, completion and remedying any defects, damages for delay in completion, if any, and all other costs incurred by the employer have been established. The employer may recover from the contractor any losses and damages incurred by the employer and any extra cost of completing the works after allowing for any due to the contractor under subclause 15.3, and then is required to pay any balance to the contractor. The contractor is required immediately to repay any amount of the advance payment under subclause 14.2. These are the consequences of default of contractor, the valuation at date of termination. Employer's entitlement to terminate, subclause 15.5. Subclause 15.5 gives the employer the right to terminate the contract for his convenience. The employer shall be entitled to terminate the contract at any time for employer's convenience by giving notice of such termination to the contractor. Basically, you have to familiar with your contract, what is the default of contractor, default of employer. They will list the grounds, so and they will mention payment after the termination. So here you have to mention only 4 items. If it is a default of contractors, then you have to see how the payment will prepare. Okay, after the termination. If it is a default of employer, how the payment will prepare and how they will pay. So these are the 4 main points you have to remember. You have to familiar. So contractor entitlement to suspend the work. This is suspend the work. The contractor is also entitled to suspend in limited circumstance under subclause 16.1 in the event of certain specific failures on the part of the employer or the engineer and upon giving the required 21 days notice. If the engineer fails to certify in accordance with subclause 14.6, which we discussed, B, the employer fails to comply with subclause 2.4, employer's financial arrangement. C, the employer fails to comply with subclause 14.7, payment. The contractor may, after giving not less than 21 days notice to the employer, suspend work or reduce the rate of work unless and until the contractor has received the payment certificate, reasonable evidence of payment as the case may be and as described in the notice. The contractor's action shall not prejudice his entitlement to financing charges under subclause 14.8, delay payment, and to terminate subclause 16.6. So basically you have to familiar as per your contract, what are the consequences, how is the process is going on for the termination, the payment, suspension, after the suspension. Like that you have to familiar with your contract. And definitely they will ask these kind of questions in the APC panel. If the contractor suffered delay and or incurred cost as a result of suspending the work or reducing the rate of work in accordance with the subclause, the contractor shall give notice to the engineer and shall be entitled subject to clause 20.1, contractor's claim. That is called contractor's claim to either EOT or payment or both, EOT and payment. After receiving this notice, the engineer shall proceed in accordance with subclause 3.5 determination to agree or determine these matters. Termination by contractor. The contractor shall be entitled to terminate the contract if the contractor does not receive the reasonable evidence within 42 days after giving notice under subclause 16.1, contractor in respect of failure to comply with the subclause 2.4, employee's financial arrangements. B, the engineer fails within 56 days after receiving a statement and supporting document to issue the relevant payment certificate. C, the contractor does not receive the amount due under an interim payment certificate within 42 days after the expiry of the time stated in the subclause 14.7, within which payment is to be made. D, the employer substantially fails to perform his obligation under the contract. E, the employer fails to comply with subclause 1.6 and or subclause 1.7 assignment. If a prolonged suspension affects the whole of the work as described in subclause 8.11, prolonged suspension. G, the employer becomes bankrupt or insolvent or goes into liquidation. So these are the grounds the contractor shall be entitled to terminate the contract. Terminate the contract. In any of these events or circumstances, the contractor may, upon giving 14 days notice to the employer, terminate the contract. However, in the case of subparagraph F or G, the contractor may, by notice, terminate the contract immediately. The contractor's election to terminate the contract shall not prejudice any other rights of the contractor under the contract or otherwise. And this is the end of the slide. Payment on termination, subclause 16.4. After notice of termination under subclause 16.2, termination by contractor has taken effect, the employer shall promptly return the performance security to the contractor, pay the contractor in accordance with subclause 19.6, and pay the contractor the amount of any loss of profit or other loss or damage sustained by the contractor as a result of this termination. So this is the payment on termination. Now let us look a few questions that posted in the chat room. Should the contractor wait until the engineer issue a payment certificate? Actually, we discussed this one. Okay. Most of the questions we have discussed in this webinar. Most of the questions I have already addressed in this webinar. So you can, you might understood. Most of the questions I already addressed in this webinar. Okay. Most of the question addressed today. Thank you for joining this MEQSA free webinar. Thank you very much. I'm going to wind up this webinar. Thank you and good night.